Good morning, everybody. This is George Smith, X-Rail, I am Hotep Jed Mutalib L. I'm coming to you this morning. goldenmoorservices, legal education. I'm not an attorney. This is just for education and research purposes. But I was watching a YouTube video this morning, and I always have a concern about the fathers that are getting dicked around in these courts and they're just getting abused, man. Fathers out there, including myself, it's just horrible what's happening. They're breaking apart families. And there's also, I just discovered that I guess the psychologists have come up with a new diagnoses for legal abuse syndrome that fathers are going through as well as kids. These judges and attorneys, man, they're just raping your estate and they're not giving a damn about who the victims are. But I ran into something fairly interesting. I looked up this case in the Illinois the Illinois Supreme Court rendering a decision on a father who was paying, a legal father who was paying child support and actually signed an acknowledgement paternity, saying that he was the legal father, and he came to find out that the girl he had raised up to 15 years old, and this cat was in the military, came to find out the baby wasn't his. And so he went to court to try to get his name removed based on the DNA results that proved he wasn't the father. Now, this isn't gonna be a long video, it's gonna be pretty short, but I wanted you guys to look this up and also give your own opinion because you have to do your own research. But I'm just gonna read a little bit here. So this is the Illinois Supreme Court. This is Justice Thomas delivered the opinion of the court. So the cause and the issue, he's going to read right here. At issue is whether a man who signs a voluntary acknowledgement of paternity can later seek to undo the acknowledgement on the basis of DNA test results. We hold that he cannot. Okay, so I'll read through this a little bit. On October 9th, 1997, Valerie Dawson gave birth to Kendra Smith. Dawson and respondent Romel Smith executed a voluntary acknowledgement of paternity 2 days later. By executing this form, now he's going to say what the consequences are. And so, actually, hold on, let me go back. Let me keep reading. I'm too excited. Let me keep reading. By executing this form, respondent became Kendra's legal father. See Illinois, some statute in the West Publishing, 2002. The acknowledgement form informed respondent that by signing it, he would become the legal father of the child for all purposes. Moreover, the form advised respondent of his right to genetic testing, the legal consequences of his decision to sign the form, and what rights he was waiving by signing the form. Under the large bold heading, Notice of Rights and Responsibilities, respondent was advised of the following. When the mother and biological father properly signed the voluntary acknowledgement paternity form, and if required, the husband, ex-husband, and mother signed the voluntary denial of paternity form, the alleged biological father becomes the legal father of the child for all purposes. The biological father and or mother may be ordered to pay child support until the child is at least 18 years old, including retroactive child support from the date of the child's birth, reimbursement of public assistance paid to the custodial parent for the child, medical costs, and medical insurance for the child until the child is at least 18 years old. You have the right to attorney, a hearing, and a right to have genetic testing. When the alleged biological father and the mother sign the voluntary acknowledgement of paternity, they are waiving those rights. Custody of the child is presumed to be with the mother. The alleged biological father may petition the courts for custody and visitation rights. So that lets you know that child support ain't got nothing to do with a real court, because they're telling you if you have a custody issue at hand, you need to go petition the courts, right? So you need to you need to start another case, right? Because child support is not the real court; it's only administrative. It's under executive branch of government, which the legislature gave to them through statute. You should have a genetic test if you're not sure who the biological father is. Yada yada yada. Responded. Okay, saying he obtained an attorney. The state moved to dismiss the complaint pursuant to section 2-619 of the Code of Civil Procedure, arguing that respondent could not pursue this action because he had signed a voluntary acknowledgement of paternity. The state relied on section 5B of the Parentage Act, which provides that the presumption, remember, they operate off presumptions, assumptions, right, of paternity arising out of a voluntary acknowledgement becomes conclusive if the acknowledgement is not rescinded upon the earlier of 60 days after the acknowledgement is signed, or the date of an administrative or judicial proceeding relating to the child, including a proceeding to establish a support order in which a signatory is a party. The state further relied on Section 60 of the Parentage Act, which provides that a voluntary acknowledgement of paternity may be challenged only on grounds of fraud, duress, and material. How did this guy's attorney not pick this up? Because right there on the paternity acknowledgement form, it tells you have 60 days to rescind your signature, and you can go to court to get your name removed on the grounds of fraud. They did not disclose the legal consequences of signing a paternity acknowledgement. So you can always get your name removed. He didn't even have to come to the Supreme Court to get this done. So this is that's why I say attorneys ain't shit, man. Attorneys ain't, and I'm not even going to read any more of that. Y'all know my story. So the fact that, the Supreme Court can only judge on the causes that are brought forth. They're not going to look up the law for you and they might give you tidbits on their decision if you know how to read an opinion by a court, but they can only judge based on the evidence and the facts. If you didn't bring up an argument, they can't judge you on the argument. They can't make a rendering on the argument. They can't adjudicate on the argument. So if you didn't bring it forth, they're not going to even take notice of it. So I want to come back up to the beginning. At issue is whether a man who signs a voluntary acknowledgement of paternity can later seek to undo the acknowledgement. He can undo the acknowledgement, but not on the basis of a DNA test result, on the basis of fraud. Now, if it would have said on the basis of fraud, we hold that he can. There would be no cannot. It would be we hold that he can. But since his dumbass attorney is part of the bar association and not really trying to win the case and just taking him for his money, and so is the plaintiff in the original lower court case, they're not trying to look out for this dude. They're like, yeah, we'll fight for you a little bit. Or maybe his attorney was just incompetent. But I could have won this case for him. You know what I'm saying? I could have been his private attorney and won this case for him. You came in on the wrong argument. So, because it says right there in the child support manual, section 8, page 17, paternity acknowledgement is a prerequisite for a child support order. So if you go back and rescind your signature, but actually, the state actually gave him the remedy that I just read earlier. I can't find it now, but I was at it earlier. There's a lot written here. But the state actually gave him the remedy, and his dumbass lawyers didn't even they didn't even bring it up. It's a sham. It's a sham. Let Golden Moors help you out. I will help you out, man. I will help Anybody willing to fight, I'll help you, man, because we're gonna attack this thing professionally, as it should be, and we do our research over here. So there was actually one more thing I wanted to address in this video, and that was looking at the Black Laws Dictionary, okay, here the Black Laws. Let me bring it up here so you guys can see. So I got a Black Laws Dictionary, and we're going to talk about remedy real quick. Remedy, because I'm hearing a lot of people saying, where is my remedy? Where is my remedy? And I don't think they know what the word remedy means. Now, I got this from Yusuf L. I think he said on the show last week that people are going into court and they're asking for their remedy. So what is remedy? Because the judge can't give you your remedy. You already have a remedy. Is like your rights. So if you don't know your rights, you don't know a remedy. So here we go. So remedy, the means by which a right is enforced or the violation of a right is prevented, redressed, or compensated. Remedies are of four kinds. 1, by act of the party injured, the principle of which are defense, recaption, distress, entry, abatement, and seizure. 2, by operation of law, as in the case of retainer and remitter. 3, by agreement between the parties, e.g., by accord and satisfaction in arbitration. And 4, by judicial remedy, action or suit. Sweet, Berry versus, you guys can read all that. The means employed to enforce a right or redress an injury, as distinguished from right, which is a well-founded or acknowledged claim. So I think you got some, I'll read this too. Remedies for the redress of injuries are either public by indictment, when the injury to the individual or to his property affects the public or private, when the tort is only injurious to the individual. So your remedy is enforcing your right or preventing the violation of a right. So people are going to court asking, Your Honor, what is my remedy? The judge is laughing at you and like, well, I'm not going to go find your remedy. I'm trying to enforce a statute to try to collect money for the state. So if you don't know your remedy, it's a little easier for me, to dick you over, and extract money out of you. You don't know your rights. Perfect. They love that. So anyway, I have another video that I'll be posting up soon from goldenmoorservices, explaining the particulars of a contempt. I'm also hearing a lot of people saying that, if you don't follow a child support order, basically if you're not paying, and this is after you've already signed with child support or you signed the paternity acknowledgement, that you could be found in contempt of court. But the U.S. Court of Appeals, numerous times, and it's 100% accurate, that a contempt of court is only in a criminal case, not a civil case. So I got case law on that I'm researching. I got about 5 cases already that I'll be explaining to you guys out there, so you guys can, take this on yourself and fight. If not, we can help you out here. We can get you to find your own remedy, or we can discover your remedy together. I do charge a little bit, a donation for my services, but the main thing is we want to educate people about their rights in these family courts. Really, I feel like they're the synagogues of Satan. That's how strongly I feel about it. But anyway, subscribe to the channel, man. I appreciate everybody who's listening to this. Fight for your freedom, man. Sometimes freedom ain't free. You got to pay a price, but trust me, the price is worth it. All right? Everybody have a good day. Peace to the gods. Peace to the Creator. And I'm out.